Good morning, everyone. Good to have you all here. We're just having people coming in at the moment, so we'll just give them a minute or so to get in, and then we'll kick off. Thank you for your patience. Okay, I'm just going to start off with a few introductions before we kick off on the presentation. So my name is Rafiq Jaffer. I'm a partner at Altamimi in the banking and finance team, and I cover Saudi Arabia, the United Arab Emirates, and Bahrain. My colleagues today include Agati Trakidi, who is a senior associate in our banking team based in Riyadh, and Mohammed Nigam, who is a litigation lawyer, a senior associate in our disputes team based in Riyadh. And Mohammed specifically looks at quite a bit of banking-related litigation, security enforcement, and specifically bankruptcy-related work that's been happening substantially in Saudi Arabia. So we're happy to have you here today. Our presentation on Saudi Arabia's new movable asset security law and the significant amendments that happened on the commercial pledge law. The way we will structure this presentation is I will start off with more on the security creation side and what are the changes that have come about. The changes that have come about, and then after that, we will go into the enforcement aspects of the law. There is a discussion box. There is a chat box on your screen. So please feel free to include your questions. We'll be taking your questions. We'll be looking at your questions. My colleague Agati will be looking at your questions as we go forward. And then during the presentation, she will read out those questions, the ones that are significant, and then toward the end of the presentation, we can also look at some questions and respond to them. Either you could ask the questions yourself, or we could pick them up from the chat box. So moving on to the next slide, just to give you a bit of the agenda in terms of what we'll be covering today. So we'll be covering obviously the movable asset security law and how it interplays with the commercial pledge law. Then we'll be talking about the new types of security that can be created under the new legislation, the types of assets that are covered, the classes of assets that are covered. Then we will go into the process and the contractual requirements for creating security under the new law and the perfection requirements. We'll talk about priority and tracing, the introduction of the new registration system, and then go into some of the enforcement and bankruptcy considerations, which my colleague will take you through. The next slide. So we had, back in 2018, we had the commercial pledge law that came out, and this was a significant departure from the previous system, where it was quite unclear in terms of how you created security. So the new law that came out in 2018, the commercial pledge law, it kind of specified that you could create security over present assets, over future assets, over bank accounts, fluctuating balances, and even floating charges. So all of these things came in. The registration system came in as well. However, there were some issues with the law, but more specifically with the registration system, which was quite cumbersome and difficult to operate. Then this year in 2020, in April of 2020, we had the introduction of the new Movable Asset Security Law. And at the same time, the Commercial Pledge Law was also amended. They also simultaneously brought in a new registration system, which is very efficient, very user-friendly, and the staff that operates it is also very responsive with any questions that come about. Now, our view, our house view of how the two laws work together is that the Movable Asset Security Law should be looked at as a overarching legislation. It's an overarching legislation, and all other types of security on movables actually should feed into that law. So for example, the Commercial Pledge Law is a type of pledge which is covered under the umbrella of the Movable Asset Security Law. So the approach that that we and other market participants have taken is that you have the you need to comply with both the requirements of the Movable Asset Security Law as well as the amendments as well as the Commercial Pledge Law in order to create a commercial pledge. So moving on to the next slide. What the Movable Asset Security Law has done has sort of created a wide variety of security that can actually be created, part of financing transactions in Saudi Arabia. Earlier, it was quite restrictive, and it was specifically you would look at a pledge and nothing else. But now the scope of creating security is much wider. And if I take you through some of the types of security. So the first one is, of course, a commercial pledge, which is governed under the Commercial Pledge Law. This is a straightforward pledge. You're creating security over a movable asset. The second one is a repurchase arrangement. Now, this should be distinguished from a repo on securities. That would not be part of this particular type of security. Here, you are talking about types of movable assets, for example, commodities or even machinery, and you're just using the repurchase transaction as a method of creating security. Transfer of ownership of movables as security, that's pretty straightforward. The next one is it's sort of an installment sale retention of title type security, where you sell an asset, you collect the price of the asset over a period of time, and during that period, the seller actually retains the title to that asset. And so it's an installment sale type arrangement, which is quite common actually in Saudi Arabia. Now here there are some regulatory issues that will also arise. I mean, the question is, what type of entity can actually provide this installment sale structure? And because there are laws that restrict it only to finance companies and companies that have an installment sale type license. So that's a regulatory point there. And then we have assignment of rights by way of security. So here we're talking about direct agreements, assignments under other types of contracts as security. And finally, you have a transfer of rights in receivables, but again, as security. So we're not talking about a factoring arrangement or forfeiting arrangement. We're talking strictly about assignment or transfer of receivables by way of security. So these are the types of security. And moving on to the next slide, we look at what assets are actually covered under this type of under the new movables law. And it covers, obviously here we're talking about movables. We're not talking about immovables. We're not talking about land. We're not talking about building, etc. We're talking about only movable assets. And what the law says is that it covers both tangible as well as intangible assets. It covers both current as well as future assets and current and future rights. So when we're talking about tangible assets, we're obviously talking about goods, machinery, the usual types of assets. Intangibles, you may be talking about certain types of intellectual property, not all, but certain types of intellectual property. Perhaps goodwill could be covered under that. And when you're talking about future assets, you're talking about something that would come into existence in the future. It could be by way of a floating charge. It could be by way of some machinery that is that's currently being procured and becomes part of the security. And similarly with rights, you could cover rights under an agreement. Those rights will be created in the future, or also something as vague as book debts. Now, looking at this, looking at the asset classes a little more closely. So we've talked about rights and receivables. That's the first one. The second one is credit balances with banks and financial institutions. So this is a very crucial one. As we know earlier, you could only create security over a fixed deposit. And now you can create security over a current account. So which means an operating account where the balances are fluctuating. And I think that's a big advantage and that's come out through the previous law, but also this particular law. And the third point is quite new. Here we're talking about commercial papers such as promissory notes, bank certificates of deposits, and bills of lading. So this is a new asset class that previously, you would not create security. You would do an outright transfer, but you would not create security over. So this law now introduces this new type of security. Vehicles. Now vehicles, again, there was no formal system of creating security or a pledge over vehicles previously, and it was always a retention of title type of structure that was used in either fleet financing or even individual car finance. And I think this what the system does is the system allows you to create the security, and I think the system is also, in our discussions with the operator, is basically they are also linking themselves to the traffic authorities. So it could ultimately prevent the transfer of the vehicle based on this registration. And then you have the usual equipment, stock, talks about agricultural products, and then immovable by attachment. So if you have a movable object which is attached to an immovable object, that may also be covered under this law. If you move on to the next slide. So here we talk about excluded assets. What type of assets are not part of this law? And essentially the rule is that if there is another registry, if there's a specific registry that covers those types of assets, then they would not be covered. So for example, ships and aircraft, very obvious. They have their own register, and so it is not covered under this law. Securities listed on the capital markets, so your securities listed on the Tadawul would not be, they would have their own security creation process, which is prescribed by the CMA. The third one is a little bit confusing, where we talk about goods deposited in public warehouses, unless the security interest has been created prior to them being deposited. So now, here perhaps you could do security by way of possession, where the warehouse keeper acts as the bailee. So it's not really entirely clear how you would create this type of security, which is warehoused, but maybe one of the ways is by taking possession of the goods. Trademarks, again, because it has its own register. Investment accounts, I think this is a significant one. With investment accounts, obviously we are talking about accounts which are regulated by the Capital Markets Authority. And these are accounts which are sort of omnibus accounts that CMA authorized persons hold with their bank on sort of a client account for their clients. So you can't create security over that, but you could possibly take an assignment of rights under the investment account agreement. So you would not create security over the account itself, but the rights emanating from the agreement under which the investment account is held. Moving on to the next slide. Now we talk about two things. One is, how is the what are the contractual requirements for creating the security under the new law? And the second is, what are the perfection requirements under the new law? So both of these things have to be satisfied to create a valid security interest. The first point, obviously, you would assume that the security contract would be in writing, but I think the second part of that, which is that it can be within another contract. So you could have a facility letter or a standard terms and conditions, which also contains the security related provisions in that. So, something which earlier it was always the security document was different. The the facility agreement was different. Now here you have the opportunity of combining the two, making it more, I guess, user-friendly for the end customer. The second point, again, quite obvious, that the security provider should have legal rights to create the security. So it should either be the owner or the lessee, have some leasehold interest, etc., in the property. Then looking at the definition of secured obligations. Now, this is quite, I think, is quite specific. So the secured obligations can be defined in quite generally or specifically. So when you're talking about it being defined specifically, it's the secured obligations are obligations arising out of for example, facility agreement. Whereas if you're talking about more generally, you could say something like all obligations of the customer from time to time taken from this bank are covered under this security. However, what's crucial is you do need to have a maximum limit that is prescribed. So you can have it more generic, but you do have to have this maximum limit. So you could say, so you could have basically an all money security which works up to, say, 100 million SAR. So something like that. The next point, again, I think this is again quite interesting, because it sort of creates the ability to create a floating charge. So security to be the security. So here we're talking about the asset to be generally or specifically described, so as to allow identification entire assets of the security provider. So you can actually have the entire assets of the security provider, sort of a floating charge type arrangement, or you could have a general or specific class of assets. So again, you could take, raw materials, for example, or book debts, for example, or, receivables arising from these sources, for example. So you can play around with it quite a bit, and it offers a lot of flexibility and something quite close to an English law floating charge. Now, one interesting point here, and why we're quite confident that this works as a floating charge, is that in the registration system, there is actually an option for a floating charge. So where it says type of security to be created, one of the types of security is a floating charge. And that's why this would be the interpretation of this particular point. Moving on to the next slide, we come on to perfection. So in terms of perfection, there are two ways in which you could perfect. One is by way of registration on the Unified Registry of rights on movable assets, so the new registry that's been set up. And the second is by way of possession. So the first point is pretty straightforward. Anyone can register, even a foreign entity can register on this system and become a security beneficiary of security on the system. The second one, in terms of possession, it could either be actual possession, or it could also be constructive possession or deemed possession. So you could have appoint a bailee, and the bailee would hold the assets on behalf of the secured party. This could be, the bailee could be a collateral manager, it could be another bank, it could be an official of the company itself, who could act as the bailee and take that control and hold it on behalf of the secured party, the financing party. Now, registration versus possession has an impact on priority, but not in all cases. So one of the places where it does not have an impact is when you talk about bank accounts and instruments which are transferable by endorsement, such as promissory notes. So taking a bank account can be, you don't register the security interest. It is only perfected by way of possession. So possession is the only method of perfection. And you find that a lot of banks actually follow that, and they don't actually register. Few banks have taken the view that because it is so easy to register under the new system and the costs are fairly minimal, it might be better to, by way of abundant caution, to actually do the registration. But under the law and the implementing regulations, you do not need to register. You only have to have possession. Now you have possession. In a sense, you have possession. So let's say the account bank is different from the secured party. So then the account bank would have to make certain representations that it is holding this account on behalf of the secured party. Coming to assignment of receivables and rights. Now here there is a requirement for notice only. So you do need to provide notice. So you don't need a consent or an acknowledgement from the underlying debtor. So to the underlying debtor, you just need to serve notice that the assignment has occurred and these receivables have been assigned by way of security to XYZ bank, but you don't need to wait for a consent. And the second point is that if there is a restriction in the contract that prevents assignment without consent, that restriction would not invalidate the security interest that's being created. So this is quite a departure from the previous where you actually needed consent for security, but now it's very clear that under this particular law, you only need to notify and you don't need to, and if there's a restriction, that restriction would not be applicable. One more point here is that you could create, under the commercial pledge law, that you could still create a pledge over the receivables or rights, and the movable asset security law talks about an assignment, and it's only in the case of an assignment that you need to serve notice. In the case of a pledge, it's not clear. So one of the approaches that banks are taking is to do both and actually serve the notice as well. All right, moving on to the next slide, and just a quick word on registration. So the new registration system called the Unified Register for Rights over Movable Assets has been established. It's working, as I said, very smoothly. It's a very easy system to use. It's not restricted to Saudi banks and Saudi entities. You can be established outside Saudi Arabia and still create security and register security. There's a 6-month transition period where if you have registered on the earlier unified register, you need to transfer that security onto the new registry, and then that priority would carry through. So that ends in October, and I think that's pretty significant work that needs to be done. Yeah, and then I think the filing of the electronic form, the search functions, etc., on the security register are very, very easy to use, very user-friendly, and I think it just requires to get onto the system and have a quick browse around to understand what's going on. Can you go to the next slide, please? Now, talking a little bit about priority and tracing. So in terms of priority, what the law says is that if you have created security under the movable asset security law, and there is some other type of security which is not being created under the law, although it has to cover an asset that would be subject to the law, it would be the security that's created under the movable asset security law that would take priority. If there is a registered security and any other type of security, the registered security would have priority. If there are multiple registered security interests, then the registered security that's first in time and date would take priority. And if there are multiple unregistered security interests, then again, the one that has priority in time and date would basically take priority. Once you've created security on the system, you have priority over labor rights as well as government entitlements. So this was a good sort of new addition to the law. In the next slide, let's talk just briefly about tracing. Next slide, please. Yeah, so the next slide. So if you have an enforceable interest against third parties, so if you have created security correctly under the law, and that particular asset is sold, for a period of 15 days, you can actually trace into those proceeds, and you're entitled to take the proceeds of that sale. And I think that's I think that's quite a difficult rule to follow, because it's only a 15-day period. Perhaps that could have been longer, or the actual date would not be specified. The limitation period would not be specified, but it is, and it's a 15-day period. So I would say that security takers, secured parties, need to be quite vigilant on when the asset is liquidated by the security provider. Just a quick word. Next slide, please. Quick word on the difference, what has happened in terms of the amendments to the commercial pledge law. So one is that the concept of the floating charge was removed, but as we saw, it has been now moved on to the movable asset security law. So in substance, that option is still there. I think the second bullet point is very significant. The scope of the commercial pledge law has been expanded by deleting the term economic debt, because the term economic debt, the inclusion of that term meant that it was only a commercial transaction that was covered by the law. And retail transactions. So, for example, if the bank is providing a retail facility for financing washing machines and vehicles and etc., where would you register that type of security? So now, by removing this, you can, even retail loans and retail financing falls under the ambit of this law. We've talked about registration. We've talked about ancillary components. So I think we can move on to the next slide. And I think the next slide, just a couple of points here as well. Enforcement, the earlier enforcement process is not, the provisions relating to the enforcement process have been deleted. And now that's covered under the under the movable asset security law. And my colleague, Mohammed Nigam, will speak to those provisions. So while the commercial pledge law retains the concept of an economic register, there is no requirement to now, economic pledge, sort of a mortgage of a commercial business, there's no more requirement to actually register that at the Ministry of Commerce. So this is, again, slightly unclear in terms of what would happen there. And then the last bullet point, which relates to limited liability, shares of an unlisted company, of a limited liability company, and a closed joint stock company. So with that, Agati, are there any questions we should take now before we go into the enforcement?
There are some questions that are focused on registration. I don't know if you want to take this now. One of the questions that we have that has been repeated is whether when filing the security on the registry, one application can be made to register multiple securities, or for each security a separate application needs to be filed. My understanding is that there has to be a separate application for each security that has to be registered. But I think, do you understand anything different?
No, I think that's correct. For each security, for each time you're creating a security interest over the same security, it would be a different filing that would be done.
Another question that has to do with registration, it's what should be the registration expiry date? Here it says that although there is a tenor under each facility, however, final maturity dates are usually defined as the date when all obligations have been settled by the borrower. Thus, the final maturity date could go beyond the tenor of the facility and may not be envisaged at day one. Question is, what should be the ideal way to record pledge expiry date? In case final maturity date goes beyond the pledge registration expiry date, will the security agent still be able to get benefit in case of enforcement scenario? I believe that the expiry date is that you would put down is the estimation of when would be the final maturity date, the date on which you would expect all obligations to be settled. If this is extended, I think that the registration would have to be amended accordingly. That is my understanding.
I think that's correct.
I think, do you agree?
Yeah, I think that what we've been seeing is, in practice, we've been seeing a buffer being put in. So if it is 10 years, they probably have 11 or 12 years as the final maturity date to keep that buffer in place.
There's also another question on secured obligations and whether they are required to be specified. How do we state the maximum amount for open money facilities? I think your point is covered with this point, Rafiq. The law says that it can be generally or specifically described, and that includes including a maximum amount. The generally described can mean that you do not need to say a specific amount. However, from what we see in the market and from what we understand that the courts prefer to see, it's always preferable that you include the maximum amount that is being secured. So again, as you would include, let's say, you would estimate what your profit element is, and you may include a buffer just to be on the safe side that this is the maximum amount and register it accordingly.
I think, Agati, let's move on to enforcement, and then we'll take the remaining questions at the end.
Okay.
Mohammed, you want to go ahead, unmute yourself and go ahead.
Thank you, Rafiq. Hello, everyone. We will start to next slide, please. Talking about the enforcement according to Movable Asset Security Law, the new law that's trusted 3 months ago, or more than 3 months ago. Here we will talk about actually this law came with new ideas, as Rafiq mentioned. One of these new ideas, self-help remedies. Yes, self-help remedies started with commercial pledge law 2 years ago, but this law actually took a different approach from the commercial pledge law. In commercial pledge law, it was prohibited for parties to agree that the creditor can own the security to satisfy the debt, but this law actually allow to parties actually, or the creditor, to be owner of the security to satisfy this debt. There is some condition and requirements to make this clause enforceable. First one should be in writing. And here, according to the law and executive regulation, this writing or the agreement could be during the agreement itself, or could be a separated agreement, whether it's in any approach will be enforceable. But the main thing, or the main condition here, is this should be before the default of the debtor. So after the default actually will not enforceable. So these two main things. The executive regulation add another thing to enforce this clause or agreement. Before taking action by creditor, the creditor should serve actually legal notice to inform the debtor of the breach and default, request from it to pay the secured obligation. There is no period or time for that specified by whether the law or executive regulation, but we prefer here or advise to be 15 days. And the reason for that, actually, commercial court law, this new law as well, issued 2 months after this law, mentioned a legal notice is a mandatory for all claims that more than 1 million SAR. So this legal notice we prefer to give a period for 14 or 15 days for the debtor. I said, this self-help remedy actually gives many options, a wide approach, more than the commercial pledge law. So the creditor can choose like public auction or right sale, or as I said, can purchase the secured creditor. And in the commercial pledge, actually, there were like some procedure to apprise and give like evaluation or evaluation for the assets. But this law also didn't state it, and executive regulation as well didn't state any of that, and just said stated it's equitable price. If we have any disputes regarding this equitable price, we can go to the competent court, if any. But that's it. It's equitable price is not even like a market price. I would say they said equitable one or fair one. From practical point of view, this will apply for all kind of securities or kind of agreement that's stated by the law. Practically, from litigation and practical as well, we cannot actually say this will work in a good way or smooth way in all cases. The reason of that, if you have a security not in your position as a creditor, and the debtor refuses actually to give it to you to enforce this clause, you cannot do anything but go to the court and take an action for the competent court. So from point of view, our point of view and practical point of view, if you don't have a position of that security, this clause, even if in writing, will be difficult to enforce. So we can take this in our consideration when we draft this, and we can put like a legal consequences, right of compensation if or damages that might caused by the debtor in case if refuse or reject our request or creditor request to give the security. The good thing also about this law is they give right to the secured creditor to take a necessary action to repair and return or improve security to actually increase the price. This might be help in a specific agreement or some agreements. And also sometimes you can have like a dispute regarding the ownership of the security. According to the law, this execution, non-judicial and also judicial, when we come, is releasing security from any right created on that security, which give like advantage for the new owner to have it with clear and no dispute in the future. If we don't have not sufficient proceeds according to the law, I would say the creditor will not have any right to claim the remaining amount. Actually, the law answers this, said the creditor will have the right to claim for the remaining amount, but this remaining will be unsecured. So the secured amount or the security will cover a part of the amount, and the other part will be unsecured, which like give some risks in some cases, especially in bankruptcy when we come to it. Next slide. If we don't have a non-judicial clause, or we have it but in a practical we cannot enforce it, so we will go to the competent court filing a case against the debtor or the one who creates the security or the security provider, I would say, for the competent court. Also, the competent court will be entitled to consider cases related to registration disputes. Sometimes we have like disputes related to the details of registration, or terminate or deregistrate the security. So if we have such thing, we will go to the competent court to resolve this. Related to priorities, and this law also stated in very explicit way, this secured creditor will have first priority before labor rights, before government entitlements, including tax or government fees, which give actually advantage for the secured creditor to get the full debt or even the most of it with minimum risks for default. As we said, is the judicial execution as a non-judicial releasing security for the new owner, so no risk for the new owner or no dispute for the new owner. If we go to the next slide, we will actually ask very important questions, especially in the bankruptcy risks. The bankruptcy is a risk for secured creditor or not. We can see the main issues that might make us ask a lot of questions related to moratorium or suspension of the claim periods, the trustee rights, especially for termination in agreement or replacing the security itself for some cases, the priorities that we mentioned in movable asset security law, and look back periods. The main issue we see is that we need to actually see if considered as a risk for the creditor or not. The moratorium, it depends on the type of bankruptcy, because we have three types of bankruptcy procedures. One is preventive settlement, the other restructuring or financial restructuring, and the last resort or last solution is liquidation. Each one of them is stated like a moratorium period from 90 days to 36 days. In liquidation, no specified period. The problem with that, you cannot take any action, this including security creditors, against the debtor. But the good thing here, the law itself, bankruptcy law, give an advantage to the secured creditor to apply to the court to get an approval to enforce security, and whether it's non-judicial or judicial. So it's a good advantage. Yes, we'll add like extra procedure, extra time, because you should take like an approval from the court, but this actually give an advantage more than the other creditors or unsecured creditors. So we'll not see actually a big risk on that. The other one, the trustee rights, especially in restructuring, because in restructuring, trustee little bit has some powers related to termination agreements, related to replacing security with equivalent security, if that in favor of the other creditors or the debtor itself. The good thing, yes, we stated like there are some exception for banks and financing companies, stated that trustee will not able to terminate such agreements. But if we don't have this type of agreement related to bank or financing, this might be a risk for the security by non-financial sectors or banking sectors. The replacing as well phase post of all of security agreements. Yes, the creditor can file an appeal against trustee, can dispute this. Might be this little bit risk. There is many arguments in that, but still we see little risk. But also, as we mentioned, and comparing with unsecured, it's a better position comparing to that. the priority actually still the same, no effect. One mentioned in movable asset security law is the same in the bankruptcy. So the security creditors still have first and priority over the movable assets. And if it has any compensation or the security not sufficient, also will be able to collect the insufficient amount or the remaining amount as unsecured or unsecured look back periods. The bankruptcy actually law stated two look back periods, 12 months in general and 24 months for related parties. Related parties, it's between manager, the one who has a business relationship or employment, or the parent companies, or the companies that managed with the same parent company. All of them considered as a definition of the law as a related party. The reason of that might be something tried to fuse the damages for other creditors. That's why it's a little bit longer for like 24 months. But also this not actually affect all agreements. Most of agreements stated in the law that will have a look back period or will consider or examined by the court or trustee during the look back periods. Actually, you will see this transaction is related to transaction with undervalue of the asset of the debtors, or I would say like transaction without consideration, or something like waiving without or assigning rights without consideration. All of that, it's kind of transaction like unfair. It could cause some damages for the creditors. Assuming that in all of you will not have this approach, we recommend if you have such cases with some debtor is in bankrupt or declared bankrupt according to the court decision, not be involved in any agreement without your lawyer, without whether in-house or your external lawyer, because it's a little bit tricky. This arrangement could be nullified because if the court considers this like unfair or something can harm the other creditors, the panel will be nullifying this agreement. But also it has a criminal exposure because in some cases the parties could consider as committed a crime according to the law, bankruptcy law, and get sentenced up to 5 years or a fine for 5 million. So not involved in that arrangement, and all arrangement we prefer to be in front of the trustee, in front of the court. In conclusion, we see comparing with the legal system we had before, this law actually considered as an opportunity to give a good position for the security creditors to actually encourage the banking sector and financing sector. That's it, and if you have any question, I will be happy to answer.
Agati, do you want to read out the questions?
Yes, there are some questions that are for Mohammed. One of them is, how will banks outside of KSA enforce security if they're not registered in KSA?
If you see, like as Rafiq said, we have this registration system. It's online. And you can see there is option for the non-Saudi to register their security. If you going to enforce this, for sure you have to get an agent, which another entity or a lawyer can enforce this. And we actually take on behalf of foreign banks and finance companies a lot of enforcement procedure here. So it's allowed by the law and stated in explicit in executive regulation as well. So you can take an action, but for sure you will need an agent here.
Okay. One other question was, can we enforce a perfected security in the event of bankruptcy proceedings against the borrower?
Again, because it's cut off voice.
Yeah. Another question was whether we can enforce a perfected security in the event of bankruptcy proceedings against the borrower. So essentially the question is, if bankruptcy proceedings are commenced against a borrower, which is the security provider as well, will we be able to enforce that security at that point?
Yeah, okay. The moratorium or suspension actually, according to some cases, could include the security provider, if not the debtor. If I understand the question right. So this actually is stipulated by the law. In some cases, you cannot take any action against even the security provider. Is that I understand is correct?
I think if I can.
Yeah.
Sorry, Agati. Yeah. So I was just saying that if the borrower is in a bankruptcy type situation, I guess at that point when you would need to submit your claim to the bankruptcy court with respect to the borrower, because there might be an unsecured component also. But in terms of the security would subsist, it would not be affected. I mean, you may need to go through the process of actually enforcing it and seeking the permission of the court to do that. But other than that, it would not impact the validity of the security just because the borrower has gone into bankruptcy proceedings.
Okay.
Okay. There were other questions. One of them was not related to enforcement specifically, whether it's possible to have a second-degree pledge in Saudi Arabia. It is possible. It is possible to have multiple security interests, and to have even multiple registered security interests. However, the one that has been registered first has priority. There's another question. In case of a change of the security agent, is there a need to file a pledge registration amendment? There would be such a need. First of all, you need to actually amend the agreement if it's a new security agent. So you would have to also file an amendment to the registration. Okay. Rafiq, I think this one is for you. What is the process of moving the rights registered in the old registry to the new registry? And what happens if these rights are not moved by October, which is when the 6-month deadline expires?
Right. So I think in the first, for the first particular question that you're asking, you would just register it as a new security interest on the new register. But then there is a place where you actually put in certain description of the property, and we would recommend that in that space you would make reference to the previous registration and keep the keep the confirmation of the previous registration as well. So that's to answer your first question. In terms of the second question, you would get priority. So what was the second part of the question again, Gati?
What happens if the security is not transferred to the new registry by the October deadline?
Yeah, it would be treated as an unregistered security. So
yes.
you and someone else might get
priority.
Yeah.
Another which is interesting is about the assignment of receivables. I think we've received this question a couple of times. That we're mentioning that the only professional requirement when it comes to an assignment is the registration and the notification of the debtor. Does that change the market view about requiring the underlying debtor to consent or acknowledge to the assignment? What should the banks be doing? Should they be getting the acknowledgement nonetheless?
I think my view is that yes, it does change the market position with respect to security. So if you're creating security, and this is not the only legislation that has this actually, there is other legislation also which relates to, I think, lease finances, which also allows the same sort of structure. So this is not new. But yeah, if you're creating security in this way, then a notification is sufficient, consent is not required. If you were doing something else, if you were doing an outright true sale transfer by way of, for some sort of factoring product or a true sale assignment to actually transfer on an outright basis, on a true sale basis, then consent would be required.
Okay. I think one other question was, how does this law correlate, if it does, with the finance lease law? My understanding is that it does when it comes to the types of security interest that it introduces now. What was it? You have the slide in front of you. Yeah.
Yeah, sorry, Gadi, I was just saying that there's a specific register for the finance lease law where you can actually, so on that, so, but that does not cover security, that covers more a transfer of the rights. So if you're taking the finance lease law, if you're trying to take security over the receivables arising under a finance lease, then that would be covered under this particular law. But if it was an outright transfer of the receivables by way of a true sale, then that would be covered under the finance lease law.
Mm-hmm. I don't know if I'm missing any question. If anybody wants to unmute their microphones and ask any questions.
Any other questions? All right. I think, look, I think this was a good discussion. And Agati, are there any questions?
I think there was a question before about the maximum amount in the security. There's a question: if we need to have the maximum amount in the security, then how can we consider that floating charges are included under such security? Well, the floating charge concept that we're using is that what that allows you to do is to take security over all the assets. Up to a maximum amount. So the only difference of the floating charge is that you as a security is that you can take it without specifying which are the specific assets that you're securing. It does not actually the fact that you would mention a maximum amount doesn't, in my view, impact the nature of the security over the asset that you're charging.
I agree with that. Yeah. Okay, I think our email addresses are up on the screen. Please feel free to reach out to any of us if you have any follow-up questions or clarifications that you require. The webinar will also be put up on our website. So if you want to revisit the the issues that have been discussed, it's been great doing this this webinar with you, and look forward to hearing from you soon. So thank you very much, and have a good rest of the day. Thank you.
Thank you.